Did United Airlines wrongfully deny a flight attendant her disability benefits because she was scheduled for hip surgery or because she took a passenger's iPad? What you need to know about ERISA 510 lawsuits. What can happen if an employer like United Airlines fires an employee who is scheduled for hip surgery because that employee allegedly violated company policy? An employee can sue the employer under the Employee Retirement Income Security Act and the Americans with Disability Act. They can sue for age discrimination. These are a number of the things that an employee can use, if you will, to file a claim. And that's what happened in this case of Clapper versus United Airlines. She ended up using all of these legal remedies. Now, Clapper was a long-term employee of United. She was 66. Age discrimination. She was having problems walking because of hip problems, and she was scheduled to have hip replacement surgery. United approved her leave for her total hip surgery, which meant she was also going to be entitled to her disability benefits. She worked out of O'Hare, and if you've ever flown out of O'Hare, you know it's a crazy place. A flight attendant found a passenger's iPad, and because there was no purser and the hour was late, she took the iPad home. But unfortunately, she left it at home for the next 2 weeks because of her travel schedule. She didn't call her supervisor, she just left it at home. Now, that was a violation of United's company policy. The passenger filed a claim and discovered, using a tracker application, that the iPad was at her home. So what happened? Well, the sheriff's office showed up, and she said, "I'm sorry, I didn't mean to take it, but here it is." And of course, that got to United. United placed her on a leave and ultimately fired her because her actions violated a company policy. Now, Clapper sued alleging age discrimination and a violation of her ERISA rights. What did the court do with this ERISA 510 claim? Well, let's talk about a little law. Under ERISA 510, an employer like United is prohibited from discrimination against a plan participant for exercising their rights or interfering with their rights under the ERISA statute. And that means medical claims, health claims, life insurance claims, disability claims, all those sorts of things that are covered under ERISA. So to be successful, an employee has to prove that this interference was intentional and it wasn't incidental, as incidental actions don't violate ERISA Section 510. So to prove a prima facie case of a 510 violation, you have to establish that you belonged to a protected class, that you were qualified for your benefits, that you were discharged under circumstances that provide some basis for believing that the employer, like United, intended to prevent you from using your benefits. Now, if the employer argues that there was a legitimate non-discriminatory reason for its action, then there isn't any need for the court to even get to the 510 claim. Now, obviously, in this case, United had a legitimate and non-discriminatory reason for terminating her benefits. I mean, Clapper took it home, didn't bring it back, didn't tell the supervisor. And of course, proving a 510 claim can be very difficult in this particular situation. Ultimately, the court ruled against her on all counts, and she lost her 510 claim. As I said, can be hard to prove. But if you think your employer has discriminated against you in exercising your rights to your ERISA benefits, call me today at 727-894-3188 for a complimentary consultation. I can help you regardless of where you live in the United States.